Good afternoon. My name is Judy Dow. I'm French Canadian and Abenaki descent, and I've been an educator for 38 years. I'm a basket maker, mother, and a grandmother to three. And I am also the executive director of Gidakana, a Native organization here in New England, where we help women to self-determine a good path in life and help them to reclaim their history, their culture, their music, their language, all kinds of things. Um, so Benedict asked me to do this afternoon, and I started looking at the laws that people were going to talk about, and I was like, whoa, they're talking about Calvin Coolidge. Well, Calvin Coolidge plays a really interesting part of my life. He was born in Vermont. Um, Calvin Coolidge was first cousins to my husband's grandfather. And so our marriage was interesting. I knew we were different from the beginning, but not quite that different. His grandfather would send me books to read and papers to read and about Calvin Coolidge, and in them he would in ink underline specific things he wanted me to know and who was who in the family connections. And it was challenging because they wanted my children to go there during summer vacation. And so my children would spend their summer at the Coolidge homestead, um, visiting their grandparents and learning about Calvin Coolidge. And that was all happening while I was doing research on my family and determined that my family was the largest family targeted by the Vermont Eugenics records. 623 people in my family were institutionalized, many were sterilized. So it's been a journey with more than one foot in two worlds, to say the least. Um, but knowledge is powerful. And so I've been working for a couple decades now to make eugenics public so people know it, recognize it, and change the laws that are impacted by it. So we have some wonderful people here with us today, and I'd like to introduce Carrie to you. This is Carrie Malloy. He is an assistant professor at the Native American and Indigenous Studies at San Jose State University, specializing in Indigenous and genocide studies. His research focuses on the genocide of Indigenous people and the ongoing healing and reconciliation in Native America. His presentation title is Assimilation, Political Status, and Dispossession, the Indian Citizenship Act at 100 years. Thank you, Carrie.
Thank you, Judy. First, I need to acknowledge that I'm coming to you from the homelands of the Muwekma Ohlone in the San Francisco Bay Area. We are at the southern portion of the bay in what is known as the East Bay. My people are the Yurok and Karuk. We are from extreme Northern California, about an hour south of the Oregon border along the Klamath River. We are salmon people, and that means that our livelihood and our worldviews center around salmon. So the Indian Citizenship Act is not just an academic exercise for me or many people that I know. It's something that plays very much into our lives. If we look at my grandmother, she was born in 1921. She was born in what we would now say are the backwoods, the upper hills, away from many of the settlements that had developed at that time and most people. So she was born as a non-citizen. She was born in the United States, not as a citizen because she was Native. She still lived amongst the Native community and didn't have the rights of citizenship. Fast forward 3 years, and on June 1st, 1924, she wasn't a citizen. By the end of the day, on June 2nd, 1924, she was, because of an act of Congress. Why did Congress do this? Why did President Coolidge sign this? Well, it goes back further. It goes back to the moment of contact between Europeans and the native populations of North America, they've always strove to be separate. If we look at the two-row wampum, the original treaty that was negotiated between the Haudenosaunee and the Dutch, it represents moving forward in friendship, but not crossing paths, not interfering with each other's future and how things operate. It's about separation. Even after the Revolutionary War, the Native tribes strove to be independent, not to depend on the United States, to be separate from it, and were regarded as that. The United States engaged in treaty making, very much like our cousins in the North with Canada and Great Britain. They negotiated nation-to-nation treaties, sovereign-to-sovereign treaties to remain independent, to remain separate, and kept those lines pretty strongly and not wanting to be part of this nation. But as we see, as the westward movement happens, as the United States begins to move across the continent to the Pacific Ocean, the US's approach to Native people changes dramatically into one of assuming responsibility for and management of Native people and tribes. It becomes one in which Native people begin to exist in a very strange legal quandary of how do we deal with them? As non-citizens, they were not part of the larger society. They weren't part of the voting electorate. Many weren't paying taxes. As the United States needed more land, they began to break up reservations. They assumed control of reservations and land in such a way that allowed them to break them up under something called the General Allotment Act or the Dawes Act. And they would checkerboard the reservations. They would allot 140 acres to one individual, a tribal citizen. Then they would allot or sell off the land next to them to a non-native person so that they could begin assimilating tribal people into a more agrarian life. This began to pose a lot of legal problems of how do you enforce laws? Who has the right to enforce laws? Who can prosecute Native people? But even more so is how do they fit into the larger society? Where do they actually belong? And how do you manage them? And I'm using the language of management because that's been the approach of the United States to Native people for centuries. It's about managing. If you look now today in 2024, 100 years after the Indian Citizenship Act, Native people in this country, all of our affairs, all of our interactions with our government occur through the Department of the Interior, which is responsible for natural resources. It manages land, it manages fish, it manages horses, it manages trees, it manages oil, it manages minerals. It is about management of a natural resource. That has been the US's approach for Native people, is it places us in this existence of being a natural resource that doesn't make us so much human as it does something to be managed and something to be dealt with. As Native people began to move in and take into the urban environments and move away from tribal centers, of cultural centers and communities, the question really came up, what do we do? More so, not only what does the government do, but what does it do to secure the lands that belong to these people? Calvin Coolidge brought together what was called the Committee of 100. These were individuals who not necessarily were Native, but they were mostly non-Native individuals working in Native communities, working for general welfare, to begin having this conversation over what do we do? How do we extend rights? How do we bring Native people into the larger society? And against Native nations' objection, the Indian Citizenship Act becomes law on June 2nd, 1924. So roughly a week from today, we will honor that anniversary. That creates a new complication. It doesn't just bring Native people into citizenship with the United States, it places them in a different political status because it doesn't extinguish their status as Native people, as tribal people. So not only are we citizens of the United States, citizens of the states in which we live, citizens of our cities, we are also separate. We are also citizens of our tribal nations. And our Supreme Court here in the US has recognized that and said, being Native is not about race or ethnicity. It's a political status you have because of your citizenship in your tribe, with your nation, which even complicates things more because as we move forward in time, we see that the United States tries to get out of the Indian business. They try to end their relationship with tribes. And we go through a period of time called termination, where the government terminated its federal relationship with tribes, creating this really bizarre new classification of Native people called non-Indian Indians, people who are Native people, the first peoples of this continent, who don't have that political status recognition, but who exist. The complications exist with today. Here in the Bay Area of California, with the Muwekma Ohlone, they are what we call a non-federally recognized a tribe. They are US citizens, they are citizens of the state of California, yet they are not recognized by the powers that be as being an independent sovereign nation that has a citizenship. So they fall into that quasi state of being a non-Indian Indian, which creates even more complications. How do they ask and receive the remains of their ancestors or held in museums? How do they gain land? How do they do all of these things? The Indian Citizenship complicated the way in which we understand citizenship for Native people. And it moved us from a status of being understood as an independent people to this weird context of a racial component that hadn't played very much into the way the government had dealt with Native people up until now. And it complicates things now as you try to explain this to students and to other people, why one person has access to certain rights and privileges and others don't, even though they are basically the same. It creates a very different understanding and something very complex that very few people in this country understand, let alone try to explain that to people who are not versed in US history or US federal Indian policy. So as we look at the 100-year anniversary, as we look at where we're going, we have a lot of work to do around education and interacting with one another and understanding how all of that folds in, comes together. Thank you very much, and I look forward to hearing from the rest of the panel.
Thank you, Carrie. So then let me introduce Sandra. Sandra Sanchez is from Guatemala and of the Quiche-Mayan descent. They are currently a history PhD candidate at Yale University, where they also work across the Indigenous and Western Americana collection at Benke Library. Thank you.
Thank you so much, Judy, and thank you, Carrie, and Benedict, especially for inviting me to speak today. 1924 has been the focus of my dissertation and much of my thinking for the last 6 years of my program, but certainly before that, especially as I think about my own identity, having mostly grown up in the United States, not being from here, being a migrant myself, but kind of fraught between an Indigenous identity, but certainly not a tribal identity and not Indigenous to North America, or to the United States of America, excuse me. My talk today is going to be looking a little bit about what happens after 1924 and why I think it's important to consider the 1924 Indian Citizenship Act and the Immigration Act together. And I was thinking a lot about this presentation the other day when I was looking at the news, and I saw that it was reported that now all 9 federally recognized tribal nations in the state of South Dakota have voted to ban the state's governor from their reservations. And the governor, Kristi Noem, has kind of been in the headlines recently, for lack of a better word, for her rather alarmist right-wing rhetoric and political platform. But her ban from the tribal reservations have gone back to these comments that she made in January of this year, in which she alleged that tribal leaders were somehow connected to the so-called drug cartels that she thinks are invading through the southern border. And in the speech that she made in January, she said something particularly interesting, which is, quote, "The sheer number of illegal migrants coming into the country has made it so that every state is now a border state." So her comments have continuously attempted to link anti-immigrant sentiments and fear-mongering about border security along the US-Mexico border to the more northern state of South Dakota and justify the imposition of state and federal authority over tribal members. Noem is like other congressmen, governors, and officials from states like Montana and Idaho that are otherwise far from the US-Mexico border, but of course border states themselves, who endorse the extension of strong border security and policing measures into their local communities, including tribal nations. The looming threat of immigration from the southern border is a kind of dominant image in this phrase that every state is now a border state. And we can link this threat, of course, to the kind of, and unfortunately prominent historical racist and nationalist sentiments since and even before the Chinese Exclusion Acts of the late 19th century, in which foreigners and migrants were presented as these invading threats, right? These dangerous floods. But on the other hand, it is somehow still true as well that every state in the United States is a border state and has been from the very moment of its territorialization atop Indigenous lands and waterways. There are over 570 federally recognized tribal nations, not including those who might just have state recognition or those in the legal limbo, or Carrie, I liked how you said it, these the strange legal quandary, these quasi-states that don't have recognition. But each tribal nation has its own sovereign borders, whether recognized by the United States or not. So it is that the United States' domestic policies on this continent have always, in fact, been a type of foreign affair, and Indian affairs is a type of international policy, like immigration policy, between hundreds of sovereign tribal nations and the US government. So every state is indeed a border state from the perspective of reservation borders and tribal nations. I begin with this sort of fraught notion that I think speaks to both the recognition of tribal sovereignty, but also anti-immigrant nationalism, to highlight the complications between immigration policy, border enforcement, and tribal sovereignty that is at the heart of my own work, on how the history of immigration enforcement has impacted tribal nations along, between, and atop the borders of the United States. One of the biggest questions that drives my work is, what does migrant justice look like with respect to fighting for tribal sovereignty? To understand this question, I argue that we must consider the history of how Native people have faced the very same regimes of surveillance around citizenship status and border mobility that has framed Indigenous political identities into racialized categories. Anti-immigrant nationalism itself articulates a disappearance of indigeneity by juxtaposing the so-called foreign with the Native American, that being the white settler identity. The intertwining of anti-immigrant policies and settler colonialism brings me to 1924, with the passage of the Immigration Act, or the Johnson-Reed Act, and the Indian Citizenship Act. In the wake of both 1924 acts, cases of deportations of Indigenous people along the US-Mexico and US-Canada border regions arose due to their apparent extra-legal immigrant status. This was precisely because of a legislative void that both disappeared and absorbed the distinct status of Indigenous people as being outside of the US settler state. Native people were both somehow non-citizens, needing to be granted citizenship, and yet also outside of the typical metrics of alienage and foreignness, because they were not seen as being from a geographically distinct country. The impossible notion that one could be deported from their own homelands was affirmed again and again in court cases and immigration appeals that debated and refuted the particular and granular circumstances that the state used to justify legal personhood and documentation. Because of the 1924 Immigration Act's definitions of what was acceptable movement, acceptable labor, officials highly scrutinized why and for how long Native border crossers sought entry into the US. Treaty rights became central to this story. As tribes navigated changes to resources, lands, and waterways, despite removal, relocation, and sought ways to politically organize against deportation. So turning to 1924, I'm going to explain a little bit of why there was a problem that arose out of this. So in the passage of the 1924 Immigration Act, there were exemption from immigration laws for Native individuals of the territories and islands that were claimed under U.S. jurisdiction, so places like Puerto Rico. Native individuals from countries like Canada and Mexico, which are distinctly not territories under U.S. jurisdiction, were not protected from these exemptions. So when the Indian Citizenship Act then declared that all Native people who were born within the territorial limits of the U.S. became citizens, suddenly those who held Indian status in Canada or those from Mexico became foreigners. If you were a Native individual who could not prove birth or citizenship in the U.S., because maybe you were born on a Canadian reserve, even if you had lived in the US, you worked in the US, and your family also lived in the US, you could be regarded as a foreigner, subject to the 1924 immigration laws that restricted certain kinds of labor and your length of stay. But what became even more complicated was that the 1924 Immigration Act famously enacts the clause that aliens ineligible for citizenship were to be barred from entry from the United States. This clause, of course, echoed the numerous pieces of legislation and court cases that specifically framed Asian immigrants as non-white and ineligible to naturalize, and kind of formalized Chinese exclusion in 1924. But in 1924, Native individuals were also ineligible for naturalization, because since 1790, naturalization laws had only applied to free white persons. And then, of course, in 1870, an amendment expanded these terms to include, quote, aliens of African nativity and persons of African descent. So by 1924, despite some holding birthright citizenship after the passage of the Indian Citizenship Act, Native people, like those living along the borders without citizenship, could not technically naturalize and thus would be ineligible for citizenship and also thus restricted from even entering the United States. Now, to give an example to clarify this, we can take the case of O. Paulus, who was a Tuscarora stenographer. On the very day of the passage of the Indian Citizenship Act on June 2nd, 1924, she had sought to enter the United States through the border port at Niagara Falls in New York to join her uncle. With an ability to read and write English and both a high school diploma and a degree from a local business school, Paulus was barred from entry. Paulus was born outside of the Tuscarora Reservation, which is in New York on the U.S. side of the border, but she had been born on the Six Nations Reserve in Ontario, in Canada, though much of her family lived on the Tuscarora Reservation. Her Tuscarora membership, however, was invalid to U.S. officials as she was born outside of the U.S. territorial limits, and she was labeled a Canadian Indian and not a U.S. Indian, and she was thus restricted from entry. After being turned away at the border, Paulus contacted the Canadian Department of Indian Affairs, who then reached out to the U.S. Bureau of Indian Affairs to implore her admission. And in the letter, the official emphasized that she was deserving, that she had, quote, all the qualities for good citizenship, but was simply missing the U.S. birth certificate, but could not naturalize to become a U.S. citizen. Eventually, she was apparently able to enter, although under which circumstances we can't be clear on, but she later shows up in the record working as a clerk in Rochester, New York. In this very same period, we see other cases, individual like hers, but also surrounding issues around labor. So in 1925 and 1926, we see a flurry of letters that arrived from various fruit and hops and other agricultural associations that had interest in maintaining native seasonal labor migrant workers, the presence of them. And it was rumored that their workers arriving from Canada were being denied entry for failing to clear immigration restrictions. Farmers like the McNeff brothers of Yakima, Washington, became concerned about the potential threat to their labor supply, especially as many believed the work of seasonal native laborers could not be replaced. One farmer expressed that the exclusion of native labor would cause, quote, a serious hardship, as it was an impossibility to get enough white people to harvest hops. The confusion over Native migrant status became an international issue, and even the British Embassy in Washington, D.C. became involved. In response to a letter written by the British ambassador, the U.S. Commissioner of Immigration, Harry Hull, argued that Native border crossers could be regarded as temporary visitors, a clause that would exempt them from some of the immigration restrictions, but that defined the regulations for one entry as being either for business or for pleasure. So if one was entering to see their family, they should have no problem gaining admittance regardless of their citizenship status. However, whether labor counted as a business, as an issue of business became a fraught issue, and attempts to regulate what was business or pleasure or labor failed to account for the long-standing mobile networks of kinship in which we see Native border crossers crossing for several reasons. Now, the regulation of Native people crossing the US-Canada border specifically drastically changes in 1928 due to the landmark federal court case McCandless v. Diabo. And in this case, the US Congress recognized the rights of specifically Canadian-born Native individuals to cross between the US-Canada border, irrespective of immigration laws. In fact, the amendment literally declares that the 1924 Immigration Act no longer applies to Canadian-born Indians. And this decision hinged on the recognition of the Jay Treaty of 1794, which was a treaty signed between Great Britain and the United States that would regulate the boundary between what would become the Canadian-US boundary. And I want to point out that in the oral arguments of the case, it was questioned whether or not the Jay Treaty rights would apply to all North American Indians, including those from Mexico. And in the case, many congressional members argued that those from Mexico would begin to quote unquote flood the southern border. And Albert Johnson of the Johnson-Reed Act, Johnson himself declared, "Would we not be confronted with the question as to what the term North American Indian means? May the Indians of Mexico and Central America be called North American Indians?" So in 1928, Congress was willing to assert that the right to free border passage under the Jay Treaty was to be made eligible to those who were Canadian-born Indians, and specifically declared this was defined, quote, not by the degree of any particular blood, but by determining if the alien is actually recognized as a Canadian-born American Indian. Across the following decades, however, this declaration increasingly becomes void as immigration officials began relying on the language of blood quantum to determine who in fact was eligible to Indigenous treaty rights to border mobility. So to wrap up, I just want to point out that by 1952, immigration issues faced by Indigenous migrants moving along between the US border region had kind of drastically changed, as we see in the 1930s and 1940s, increasing attempts to regulate who exactly is allowed to cross into the United States. And so just an example of some of the cases that have arisen after 1928 in this amendment, there was a case of a child, the child of a white woman and a man who had one half blood quantum, but the child's father was not enrolled and did not have Indian status in the eyes of the Canadian government, so that child was denied entry. However, we see a case of the wife of a tribal member, and this tribal member had Indian status in Canada, and because she had married him, she was admitted under this amendment, even though she was a white woman and did not have any Indian blood in the eyes of the Canadian government, because she had married into it. Another case you see is the wife who was full-blooded, recorded as full-blooded. She was married to a Filipino man. This occurred after 1934. This Filipino man was excluded under Asian exclusion, which had been extended to Filipinos after 1934. And so even though his wife was full-blooded and counted under the 1928 amendment, she was denied entry under Asian exclusion. And so we start to see a host of cases like this in which individual officials are trying to scrutinize, and in fact themselves are becoming these kind of race makers at the border as they are contending with cases of people arriving. And by 1952, with the next major U.S. immigration legislation, the McCarran-Walter Act, we see actually that this border passage, which in 1928 was declared not to be by blood, became restricted to specifically individuals of 1/2 blood quantum. And I believe today it is now 1/4 blood quantum. And so the kind of issues around or the transformation from the 1920s to the 1950s is something I look at in my dissertation, and looking at how the terms of race and belonging and nationality start to change this transformation of Native political identities into these racialized categories. I'm going to end my talk there. Thank you very much. Happy to answer questions.
Brilliant. Thank you, Sandra. It looks like we may have lost Judy temporarily, but it's just one of those days, but hopefully she'll come back in. But fascinating talk, and great to now move over to Nicole Burns. And Nicole, thank you for joining us. Nicole Burns is a PhD candidate at the Balseal School of International Affairs, University of Waterloo, specializing in global justice and human rights. Since 2016, Nicole has been engaged in community-led capacity building, primarily working with Indigenous communities across Canada on various health and wellness initiatives. And Nicole today is going to talk the compounding impacts of land displacement on Indigenous peoples, considering mental health and continued resistance to colonialism. Brilliant. So over to you, Nicole. Thank you.
Thank you so much. Really excited to be here today. Thank you, Sandra and Carrie, for your great presentation so far. I'll just jump right into mine here. Just to start, I want to do an introduction of myself. So I do live and work on the traditional territories of the Channahton, Anishinaabe, and Haudenosaunee peoples. And I am an uninvited guest to Turtle Island, also known as North America, with mixed European heritage. And I approach my work as an ally in partnership with Indigenous nations. So this is often upon request and an invitation to work on projects. And I want to point this out because there is still a lot of bad research being done out there, extractive research being done by non-Indigenous people. And it's very important that I can center my identity in this and call attention to my positionality. And I use decolonial theory, Indigenous research methodologies, and community-based participatory research in the work that I do. So just a short little overview, a lot of the work that I do is based around health and wellness, as well as land rights. And these are intimately connected, especially for Indigenous peoples, as I'm sure you've heard a lot about today already. So I will just talk a little bit in particular about a study that I was part of recently from that was published in the Lancet Journal of Planetary Health. So this was a systematic review that was done upon request of West Moberly First Nation. And it was part of a legal battle against BC Hydro, the Canadian federal government, and the provincial government. And the legal case asserts that the Site C dam would destroy their territory and violate their rights. So this is one example of a study being requested by an Indigenous nation, combining the land and health aspect of things. So I was on a team for this study, and I just want to highlight some of the findings from the study and also add that this systematic review looked at studies that were done in Australia, New Zealand, North and South America, and the circumpolar North. So it was a pretty wide scope, and we were specifically looking at the mental health impacts of extractive industries that resulted in land dispossession. So a lot of studies have been done on the physical impacts, but not that many have been done specifically on the mental health impacts. And so that was our main focus. And a lot of the findings are quite similar, but the findings from this study are more focused on mental health. So we see that Indigenous people's relationship with the land is a key determinant of health and wellness, and is actually a key determinant of a key social determinant of health in general. So land dispossession, also known as the taking or using of Indigenous land without consent, has contributed to a loss of language and culture, interrupted the transmission of knowledge, and become a source of intergenerational trauma. Land dispossession and its consequences have entrenched the varying health outcomes experienced by Indigenous peoples globally. So in other words, when you inevitably read a bunch of health articles that talk about Indigenous peoples and report the low socioeconomic standing or some of the worst health in the world, it is a direct consequence of land dispossession due to colonial policies. So this is the legacy of many of these colonial policies that have continued to morph over the years and change to keep colonial agendas at the top. So just want to highlight this infographic that was drafted based on the results from our study. So we see here on the left-hand side that we have community and individual wellness directly tied to the land and with identity, strong cultural practices, and self-determination. But then we have here we have land dispossession due to industrial resource development specifically, although it can really be said that land dispossession in general leads to a lot of these same impacts. We have many different phases of impact. So initially, like the impacts of land dispossession include losses of ways of living, traditional land used for sustenance, as well as spiritual practices and burial grounds. And then we also see the impact of the industrial activities, which is an influx of non-Indigenous people, increased availability of alcohol and drugs, and also short-term jobs with high income, creating disparities in the community, and also scarcity of affordable housing, these types of things. So these impacts together lead to social impacts like cultural losses of language, spiritual connections, traditional knowledge, sense of identity, as well as the interactions with non-Indigenous people. We have increased experiences of racism, sexual violence. We have a family breakdown, increased domestic violence against women and children, and we also have outmigration of people leaving the community. And then as you see on the right-hand side, we have mental health impacts, and we have the arrows going both ways. So it's one of those complex things where you can't pinpoint exactly the order in which things happen, but it happens in a cycle, right? So all of the impacts trigger negative mental health impacts, such as grief, stress, sadness, depression, hopelessness, suicidal ideation, and substance abuse, which then in turns triggers back into the social impacts. And so we have this negative cycle that happens. And so, unfortunately, despite progress in domestic and international law and policy, land dispossession continues to be the biggest threat to Indigenous lifeways today. And I have this quote up here by Leanne Simpson, who says, by far the largest attack on Indigenous knowledge systems right now is land dispossession. So this is unfortunately still an issue. It's not something that simply existed in the past. Some other work that I've done was working with Matawa First Nations in Northern Ontario, doing a case study on free, prior, and informed consent. And so internationally, Indigenous peoples, like framed in international law, Indigenous peoples have the right to free, prior, and informed consent, being able to say yes or no to development on their lands. But with it, as is with Matawa First Nations, saying no, and then the government still comes in, doesn't respect the rights. That's the same as we're seeing with the example for West Moberly First Nation, who hired to have the legal case. They said, no, we don't want Site C Dam. It's going on anyway, so their only option is to seek reparations through a legal dispute. And this is unfortunately the case with many First Nations in Canada and across the globe. So I do most of my work within the Canadian context, which is where these examples come from. And then I just want to bring attention to the fact that land-based and place-based health and healing initiatives addressing traumas of colonization have been shown to improve Indigenous people's mental and physical health and restore community-specific ways of knowing, being, and doing. I really like to not end on a detriments note. So I know that it's important to be educated about the harmful impacts of colonialism and the continued ongoing policies of the Canadian government, US government, and so on. But there are Indigenous peoples, we've heard examples already of some great initiatives here from our panel, but reestablishing and strengthening traditional government across the globe. In my PhD research, I actually am looking at Indigenous self-government and see many examples of traditional governments being restored or reestablished. Also, the same is true with Indigenous traditional healthcare, education, language, and subsistence living. So I just want to thank you. I'll leave my presentation at that, and I will stop sharing my screen now. Thank you.
Thank you, Nicole. I apologize for cutting out on you. We're having a storm here. Lost my power. It's kind of hard to do a Zoom call without electricity, right? Very much to all of you. And I have a few questions for some of you. Carrie, you talked a lot about um, people um, hmm, having this independent streak, the Karuk people having this, and Yurok people having this independent streak. And I'm just wondering, um, everything you talked about, how that impacted the Caruth River, Kalmuth River issue that they just went through a few years back and trying to reclaim it to get access to the salmon.
So the Klamath River runs from southern Oregon down across northern California. So it sort of goes like this out to the Pacific Ocean. And we share that with the Klamath tribes up in Oregon and such. On either side and throughout most of Oregon area, there are a lot of potato farmers, a lot of agriculture. Once you get into California, it transitions to timberlands, all that. So that's sort of a context for understanding this. That independence comes from the Yurok tribe was in a very strange situation up until 1985. It was a group of individual tribal people who were recognized by the government as being recognized Indians. However, they were not a formally organized tribe. After 1985, they become recognized, they become organized. And the whole basis of those recognitions along the Klamath River for the Yurok, the Karuk, and even up to Klamath was that they had a subsistence source of food based around salmon. What we begin to see in the latter part of the 1900s into the early 2000s is this push saying, everything you as the United States government promised us in our ability to live and maintain our culture and our life, you haven't provided. So the tribes take it upon themselves to begin doing a couple of things. First is, as we've heard, land is extremely important. They began reacquiring land within their own traditional land base and then rehabilitating that land. Then they begin the process of having to break down the barrier between Native people and non-Native people over who has access and who has rights to water. They do that independently of the federal government. They begin to have those conversations one-on-one, going up and meeting with the farmers, having this. It gets very tense until what we call the fish kill. There was a massive fish kill in the early 2000s where millions of salmon died because of water temperatures. And that brings on commercial fishermen who are now economically impacted. So they all come together, and the deal, they were close to a deal. The deal was ready to be signed shortly before President Obama administration ended. The deal did not make it through Congress. It fell apart. But the tribes didn't give up. The tribes went back and continued to push and push and push, and actually have a deal now in which the 4 dams along the Klamath River are coming down. 2 are down. There are 2 more that are still in the process of coming down. That's done independently of the federal government. The federal government has not passed the legislation. What they ended up doing was working with the dam operators, and the dam operators agreed not to seek renewal of their operating licenses. So that independent streak still exists in a way saying, look, we can do this without you. We just have to find a different way of doing it. So that streak's still there. And it just, sometimes you just have to look at the federal government, say, thank you. Could you just step aside and let us do our job?
That's awesome. Thanks, Carrie. And Sandra, I cut out near the end of yours, but I heard the most of it. And you gave some Haudenosaunee examples. And I'm just wondering if your research has seen any interplay or any results coming from lateral oppression. So you're talking, Canadian government, the US government, the interaction between tribes going back and forth. Because I know here in Vermont, there's a lot of issues that go back and forth between still today. And it's getting picked up by the local tribes as lateral oppression. Are you seeing that with the Haudenosaunee?
Just so I understand, when you're saying lateral, do you mean like intertribal or? Yeah, yeah. So the Haudenosaunee examples are, I usually use them because they're the most well known. The case, the 1926 case that leads to the amendment for the recognition of the Jay Treaty is because of the Haudenosaunee-led Indian Defense League. It's a Mohawk man who ends up challenging his deportation. But one of the things I look in my dissertation is like across the entire U.S.-Canada border, and then also examples from the U.S.-Mexico border. So just to say that the Haudenosaunee are fairly well known for this, just because they have long-standing kind of political organizing against citizenship, against both the U.S. and the Canadian Department of Indian Affairs. One of the things that comes out when I was looking at, and I have all these deportation cases, is yeah, you do get instances of tribal members on the US side and the Canadian side who are upset with each other because of the kind of restrictive economic conditions. So for one example, to go back to the Tuscarora, who are part of the Haudenosaunee Confederacy, there's this instance of a man who gets deported that is sort of a test case prior to Paul Daibo, who's the one that's at the center of that court case. So he is from the Six Nations Reserve. His name is Job Henry. He's really good friends with Clinton Rickard. Clinton Rickard is the founder of the Indian Defense League, whose organization kind of leads a lot of this. And Clinton Rickard is writing to the Department of Labor and the U.S. Department of Immigration, saying like Job Henry is getting stopped at the border. He, his wife and kids live on the Tuscarora reservation. He can't come over. Like, please help me. They won't let him in. And you get then another Tuscarora clan chief writing to the same U.S. officials, being like, Job Henry is a criminal. He's diseased. He's squatting on our reservation. He, just like all these other Canadian Indians, are coming over. Many people are working in the automobile industries in Detroit, in the Detroit-Windsor borderlands. And this letter, along with some of these other ones, are saying like, oh, these Canadian Indians come over, they're taking our jobs, they are squatting on our reservation, and they're using the fact that the immigration officials can't distinguish between who's a U.S. Indian and who's a Canadian Indian. So you absolutely get this. And in the instance of Job Henry, again, this ends up being like a personal conflict between Clinton Rickard and the guy who's writing to the who's writing in opposition. They like clearly don't get along, and all there's a lot of other issues that go into this. But you see this also in British Columbia, in Washington. And one of the things that I am kind of looking at and trying to kind of frame this moment around, like, okay, well, it makes sense in some cases, if you're thinking about what it means to protect tribal sovereignty, that of course, like, protecting reservation borders is really important. And again, to go back to kind of the tension between like Akwesasne and Kahnawake, is because of a lot of the kind of opportunities around the tourist economy. So a lot of people who are selling baskets, who are selling beadwork, crossing the border to do so. There's these agreements for certain people to do so in Niagara Falls region. And so there's like opposition between, well, you know, I'm a US Indian and I have the right to sell my wares here in Niagara Falls, and the Canadian Indians that are coming over, they're taking that away. You know, we can't just go over to Canada and do the same thing. So you absolutely see this, but it's within this larger infrastructure, right? This border infrastructure around immigration enforcement, and like who has the rights to do these things. And the fact that these reservations, which, as Carrie has kind of given us a good illustration of, have been shored up through allotment policies, right? Have been kind of systematically eradicated in such a way that people are really protective of their rights. And I just to say one more thing about this is that in the present day, when we're looking at one of my kind of like ongoing, or my newer project is looking at like post 9/11, there's a lot of changes that happened to immigration enforcement. And we see tribes that are working with Border Patrol now to kind of stop migrants coming onto their reservation, again, along the US-Mexico border. And of course, there are tribes that are working against Border Patrol. The Tohono O'odham are kind of split on this. It's kind of the well-known example of this. But of course, again, when we're thinking about what it means to protect tribal sovereignty and what it means for like a just immigration policy, those things kind of come up against each other, and we have to think really carefully about what it means. If a tribe is anti-immigrant and wants, you know what I mean, like it wants to protect its own borders, reservation borders, like then to respect tribal sovereignty, right? Then the tribal government has its right to do that. And actually it would be wrong to go in and be like, well, you know, open your, you know, all this stuff. So anyway, that's all I'll say on that.
Yeah, great. Thank you. I was when Nicole was speaking, I was thinking of your presentation because you see a lot of that happening between those who got state and federal recognition and those who did not. And it plays into that. Well, if you get recognized, you know, we'll protect you, but not this one. And so then you get to see that lateral oppression. Thanks. Nicole, I did get to listen to most of your presentation. Thank you. So the question I have is, do you, well, you know, I wrote it down. What are some of the ways to mitigate the negative impacts of past and present colonial policies, and how to, at this point, not mitigate, but change the future?
Thanks, Judy. I have some insights. Of course, I don't hold all the answers, but based on my experience, you know, things like this are really great for education, awareness. Not everybody is aware of what's going on, unfortunately. We have seen a pretty big change in public awareness in Canada recently with the uncovering of the mass graves at residential schools. So we have been noticing some positive changes with the general awareness and public awareness. So that's one example, is that when more people have an understanding and awareness of what's happening and the negative impacts, then the more people can get behind changing policies and you know, advocating for change in their governments. But in terms of like Indigenous health and well-being initiatives and land rights, where I've partnered with many Indigenous communities, and really it's just about listening to each nation, each community, what works for them. And I think that's a really big piece of it, because so many outsiders want to go in and say, you know, I have an answer, why don't you try this? But really it should just be a listening, a context specific piece when it comes to the actual healing and progression, like new initiatives, programs, services, things like that should be Indigenous led, and it should be, you know, distinctions based, and recognizing that all Indigenous nations are different, their cultures, languages are different, the way they do things are different. So that's a key piece that I think is missing when a lot of people who mean well, you know, try to go in and make positive changes, but they're really missing the boat on that. And then, yeah, I think like in terms of my work, I try to hold my governments accountable for the laws and policies that they have signed in support of Indigenous rights, right? So Indigenous rights are inherent rights. They're not being granted by colonial governments. However, you know, the Canadian government, as well as the US government, have signed on to international covenants that uphold Indigenous rights, and Canadian law domestically protects Indigenous rights. So if my colonial governments have signed these things, they should be accountable for upholding them. And that's where I kind of place my power that I have in my work that I do, like aside from like my activist work on the side. So I think that's the starting point, I would say, for that question.
Great. One more little question. I think we have time. In 2015, with the passing of the Truth and Reconciliation Commission, and the creation of 94 statements by Indigenous people of what would help them, Canadian Indigenous people, what would help them to heal. How do you feel that's working or not?
I feel that it has it wasn't that alone that's, created the progress. There are still so many unanswered calls that the Truth and Reconciliation put out, but it is something to hold the Canadian government accountable. And it has been used, and I've seen it be used in a positive way. So I do think it's helping create the positive change and also the public awareness and accountability for the government. But unfortunately, the timeline, we're much further behind what the Truth and Reconciliation Commission detailed in their report. So there's still a lot of work to be done.
It says, how would you situate the policy of eugenics within the political economy of colonialism of the capitalist settler states and now in the transition to the current transnational global economy? So I think it's more a general question for everyone, really.
Anyone want to take that?
I kind of think about this. I don't know if it'll fully answer or like exactly answer this, but it makes me think about, especially this part about the transnational global economy, about the language of like migrant crisis today, and how I think often about we talk about immigrant rights, like when people come to the United States, which are really important, right? To think about, like, it's not enough just to say we should abolish citizenship, because like there are real protections that come with citizenship. And of course, there are many things that just being a citizen doesn't protect you to. And then of course, citizenship itself is fraught, right? But I think it's important to also talk about, when we look at immigration policy, and this is why tribal sovereignty and like centering tribal sovereignty comes into this, is that we should also be protecting migrants' right to stay in their home countries. And what is happening as like that arises from these migrant crises, right, is like this I'm thinking about Latin American context or Caribbean context, right? People are migrating, needing to come or leave their countries for reasons of longstanding U.S. intervention, longstanding effects of this kind of global economy that has put pressures on and forced people into labor resources. It is caused, we are seeing more and more climate migrants, and the responses of governments around the world to kind of be these national, to kind of perpetuate nationalist policies around immigration, when the big countries like the United States, like like the UK, have been directly involved in the reasons why a lot of these people are leaving their home countries. So I think about immigration policy again with the kind of eye towards protecting traditional homelands, but also to kind of think about what happens when people can't stay in their homelands. How do we protect them as well? And from Guatemala, a lot of people coming from Central America are Indigenous themselves. And so when we look at how migrants are being treated, right, there's also this like racial rhetoric around like, oh, they're all Mexicans, they all speak Spanish, right? And we're not at all equipped to help Indigenous migrants access services, access rights in their own languages. A lot of things that Nicole is talking about around wellness, right, come into play here. And so if we think about, again, like what migrant justice means with protecting Indigenous sovereignty, with protecting the right to mobility, the right to economic livelihoods, right, we can kind of get away from some of that the racialized rhetoric that I see as a kind of legacy of eugenics. So hopefully that gives some kind of help for that question.
Great, thank you. And I'd like to add a little, if I could, just to wrap it up. One of the things that I work on a lot of state committees and commissions around climate change. And one of the things that I see is that it's difficult for people who are not Indigenous to not put economy on the top of the pyramid, and land. In order to have a healthy land, a healthy economy, you have to have a healthy land. And so the land has to be on the top. It has to be on the top of the pyramid if we're to survive. And the only way we can make that happen is to educate. We have to educate people that around the fact that Indigenous people's voices are different and they have a different narrative to tell. And healthy land is at the top of their way of thinking. Thank you for everyone. This was great. Have a good day.